The parole evidence rule is a contract law principle that generally prohibits the introduction of any extrinsic evidence contradicting or varying the terms of a complete and final written agreement. Extrinsic evidence refers to any evidence outside the four corners of the written agreement. Article 2 has its own version of the parole evidence rule. Found in Section 2.202, the rule says that any term on which the parties' confirmatory memoranda agree, or any term set forth in a writing intended to be final, may not be contradicted by extrinsic evidence of a prior or contemporaneous agreement. For example, imagine a car dealer negotiated to purchase several new vehicles from a manufacturer. After weeks of negotiations, the parties executed a final written agreement stating that the manufacturer would deliver a truckload of cars to the dealer for $90,000. If the dealer later disputed the parties' agreement, the dealer can't introduce evidence of a prior written or oral agreement in which the manufacturer agreed to a price of $70,000. Similarly, the dealer can't present evidence of a contemporaneous oral agreement in which the manufacturer agreed to deliver 2 truckloads of cars. Both types of evidence contradict the parties' final written agreement and are barred by the parole evidence rule. Section 2.202 distinguishes between partially integrated and fully integrated agreements. This distinction affects the admissibility of certain extrinsic evidence. A partially integrated writing is a writing intended to be the final, but not complete and exclusive, expression of the parties' agreement. Although the writing may contain many of the contract's terms, it may also leave some terms open to interpretation or allow for additional terms to be added later. Consistent additional terms, that is, terms that are reasonably harmonious with the written agreement, are generally admissible to supplement or explain the terms of a partially integrated agreement.